to talk to you now a little bit about the due diligence aspects of an oil and gas transaction. Just like any other deal, the buyer is going to want to do their due diligence to know what they're buying. And as Jim had stated before, the role of counsel can really vary by the type of transaction and the type of company, depending on what sorts of resources they have in-house and what they're going to outsource. So here, pre-signing, there's very little title and environmental due diligence compared to what you would think. You might look at a phase one, but you're not going to do your own phase one assessment until after the signing occurs. You might ask for a schedule of expiring leases, but not look at those leases right away. It's important to know whether there's leases that are held by production or whether there's no wells on the leases, so that you know whether you can space out your drilling or if you have to spend all the money in your first year. It's an important difference. And Jim, I don't know if you want to talk anything more about that.
Yeah, I mean, I think the one thing that's a little bit different in an oil and gas transaction, typically in most normal M&A transactions, almost all of your due diligence is done prior to signing. In oil and gas transaction, it's typical that title and environmental due diligence is done between signing and closing, and that is something you should be aware of. It's normal for these type of transactions, even though it may not be normal for your typical M&A transaction. Your pre-closing due diligence then is usually focused mostly on accounting and operational matters, and less so on title and environmental.